All right, good afternoon, everyone, and welcome to our May installment of In the Boardroom with attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. I'm Sarah Deidre Kasdorf, the Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I will serve as your host today. Today's webinar is on the topic of public records. Andy and Jake today are going to talk to us about the state's public records law, as well as a number of recent court cases impacting the public records law, as well as some legislation that has been introduced on the public records law as well. So before I turn it over to today's presenters, just a couple of quick housekeeping notes. First, this webinar is being recorded, and the recording will be placed on the WCA website along with the PowerPoint presentation. Second, if you have any questions during the webinar, we will be monitoring both the chat and the Q&A features of Zoom. So please feel free to input any questions or comments you have within the chat and the Q&A, and Andy, Jake, and I will be monitoring that throughout this session. So with that, we have two members of the team from Attolles Law joining us today. We have Andy Phillips and Jake Curtis. And at this time, I'm going to turn it over to Andy and Jake.
Thank you, Sarah. Good afternoon, everybody. Welcome to the next installment of In the Boardroom. As Sarah mentioned, place your questions in the Q&A or chat, because in the boardroom, it's a discussion, not necessarily a simple presentation. We wanted to talk about public records today because we've been getting a lot of phone calls from county officials and corporation counsel with some particular issues that arise under the public records law. And the thing that you have to remember is the public records law was drafted many years ago, decades ago, and we're trying to apply those laws to today's current environment from a technological standpoint and also just an operational governance standpoint. And so it can be challenging to apply an old law to current environment. So we wanted to provide an update. So this is going to be more than just a refresher on public records. It's going to be a little bit more of an in-depth look at some of the particular issues that we are seeing counties confront on a daily, weekly, monthly basis. Very important point here. Whenever a county official, board member, department, office, whatever, receives a public records request, my question for you is, what is your process for handling that records request? Because it's very important from a process standpoint that you understand how to process that request and fulfill that request. You have a resident expert on public records in your county. That is your corporation counsel. Whenever you have a question about public records and the application of the public records law, talk to corporation counsel because they are the expert. If corporation counsel needs outside assistance, corporation counsel can be the one looking at assistance from the attorney general, looking at assistance from outside counsel, and so on. So be sure to lean heavily on corporation counsel as it relates to public records law compliance. So without further ado, let's get into public records. And we want to talk about just a couple of very foundational, basic things, all right? This is foundational and basic in that there is a statement of policy contained within the law as it relates to the purpose of the public records law. You don't see this anymore from a legislative standpoint through the Wisconsin statutes. When new laws are adopted, those new laws do not contain these types of policy statements. And so this is a bit of a rarity in the law to have a policy statement like this. Nonetheless, even though it's a statement of policy and it doesn't proscribe certain conduct or define certain categories of misconduct, the statement of policy is cited in every single case that we see as it relates to public records law. In other words, if you are in the unfortunate position of standing before a judge and the judge is evaluating whether you did what you were supposed to do under the public records law, the other side is going to cite this policy statement and the court is going to cite this policy statement in its decision. This policy statement, therefore, is important. Understand that it's the public policy of the state to provide the greatest possible information regarding the affairs of government, and that filling public records requests, that's an essential function and an integral part of the routine duties of county government. So even though at times it's distasteful, at times it's difficult, at times it's time consuming to fill public records requests, the legislature has said it's an essential function of our position. So we have to do it. The presumption is that we are going to have complete public access except in the exceptional cases where access can be denied. So again, we like to start with this foundational discussion as it relates to the policy behind the public records law. So when we think about that policy, the right to transparency, the right to access to information and records, understand when we talk about that presumption of access that the only way that we can refuse to disclose a public record is if a statute tells us we can refuse, there is a court decision on the books telling us that we can refuse access, or we've undertaken this public policy balancing test, and the harms associated with disclosure of the record outweigh the harms associated with not disclosing that record. And so, the harms associated with maintaining that record in confidence. So when we look at the reasons as to why we can refuse disclosure of a record, it is construed, again, narrowly and has to be on one of these three bases. Jake, I've been talking a lot. If you want to jump in, you can feel free to jump in at any point here.
Yeah, no, I mean, I think these are two really important slides to begin with, and Andy is absolutely right. So in preparation for today, I just read 4 cases, just trying to kind of brush up on some of the important cases that we're going to talk about. Every single one started with that opening slide with the language from the statute indicating that there's a presumption of access to these records, every single one. And so when you're analyzing these, I think it's really important from a logical standpoint, particularly as corp counsel or department head, if you're working with somebody that's the custodian of records and they may not have as much of a familiarity with the public records law, that you just get them in that mindset that we're starting with the presumption of access to the records. And then we're essentially working backwards from there. It's not the inverse, right? We're not assuming that there's not access unless a specific statutory authority exists. That's not how our Wisconsin public records law is set up. It's the exact opposite. We're starting with the presumption of access. And then if you can point to a statutory exemption, well, there's your exemption. And then common law and balancing test, even more kind of ambiguous, where you're essentially weighing that the public's, and even there under the balancing test, you're weighing the public's right to access those records against some right or authority that has been recognized in case law, because that's where you're going to find the balancing test cases, right? The statute simply references a balancing test, but it's a test that's going to be applied in a case-by-case basis. And that's why Andy also pointed out when we started, this is a very case-specific area of the law. And so again, if you're working with somebody that may not have that familiarity, you're going to have to help them navigate and understand the cases and how the balancing test has been applied. It's not an easy exercise.
So when we look at the statute, it does provide certain definitions, and those definitions have been parsed over the years by courts. But of course, as it relates to any obligation that is imposed upon county government by law, we look first to the statute. So what is a record? Understand that it's defined in a very broad fashion. It is any material on which written, drawn, printed, spoken, visual, or electromagnetic information is recorded or preserved. This gives you an idea of how old this law is, because the term electromagnetic is not a term that we hear used very often nowadays. But when we think about the definition of record here, understand that it is a very wide net that is cast. It's any material on which any of written, drawn, printed, spoken, visual, or electromagnetic information is recorded or preserved. Very broad. And the statute continues, regardless of physical form or characteristics. All right. So it doesn't matter what form that information is kept in. If it's kept, it constitutes a record. The key here is the last phrase, which has been created or is being kept by an authority. An authority is defined in the law as well. This gets to the point that we will talk about in a bit, where there has to be a connection, a nexus, if you will, between the record that is being requested and the official function of the office or the authority from whom the record is being requested. So we'll get into it a bit later, but a grocery list, for example, would not be a record because it's not created or being kept by an authority. That's a purely personal note. All right. Go ahead.
Well, so in my opinion, And Andy and I do a lot of board trainings for counties, school districts, and towns, and we run the gamut here. This is, in my opinion, the most important point out of every slide. And that is because when you get a new, or in some cases it can be a veteran board member, right? And I guess from a kind of intuitive standpoint, it makes sense. They focus on their official email address. They have, if they have a county provided phone, they'll focus on that. And I always try to get through to new members. It's content. So if you look at the definition under 1932 sub 2, it's any material on which written, drawn, so on and so forth, right? The emphasis here is the content of the communication. And so, if we're doing a board training and I don't have a lot of time to, left to talk about records, I summarize it in this one point. Focus on the content of the communication, not the device that's being used. Because now, as Andy alluded to, the public records are really trying to catch up with technologies, because now it's not just email, it's not just text messages, it's social media messaging platforms. So whether it's Twitter, Facebook, LinkedIn, all the other ones that I'm not even really familiar with, right? They all have a messaging function. If a board member is using those social platforms to communicate relating to county business, right? That has a connection or a nexus to county business, that is a record. And so this becomes a very difficult exercise where, and as corp counsel or department head, it's incumbent upon you to make clear to the board members or staff or whatever the scenario is, that you're not just searching your official email. If you've been conducting business on personal email, again, the content is what's most important. You're creating potentially a record. If it's your personal cell phone and you've been using it to text relating to county business, you are creating a record. And then the third category, like I said, is social media. We're seeing a lot of board members and even some staff where they use, and there's nothing wrong with this necessarily, but it is creating problems in the sense that if you're using Facebook to communicate relating to, particularly a board member, right? You're having a debate with a member of the public relating to a resolution or an ordinance that's before the county board. You're communicating with that member of the public. You're debating the issue. Those are records. The reality is they're not easy to capture, right? So it's a lot of screenshots, and there is technology where you can download those records. It really takes an IT professional to do that. Same thing with text messages, a lot of screenshots. I mean, I've been involved in public record situations where literally we're sitting with hundreds, thousands of pages of screenshots from text messages because you've had board members who have been texting on a matter for months, maybe a year. That's a lot of text messages. They're not easy to capture, but under the public records law, again, it really doesn't matter what device or medium you're using, it's the content.
All right, so I started with this question. What's your procedure for handling requests when they come in? Number 2 point takeaway. What is your county's official policy as it relates to conducting county business on county equipment or personal equipment? In other words, do you provide an email address to all of your board members and everybody in the county? If the answer is yes, there ought to be a rule in place that says you do not conduct county business utilizing personal devices. Why do we do that? Number one, we want an adequate record of what is happening and occurring. But number two, you want the ability to respond to these records requests without having to go to that particular supervisor or other member of a committee and say, hey, by the way, give me your cell phone for a while. I got to take a look at it. So that's number 2 takeaway. All right, so what's not subject to disclosure? The law also defines what's not included. So the law defines what's included, and it's very broad. It's a broad net, but here we have in the statute itself, the definition of things that are not included: drafts, notes, preliminary documents, similar materials prepared for the originator's personal use or the originator of a person for whom the originator is working. So when we think about the grocery list that happens to be written on the legal pad that is contained on the desk of the county official, that grocery list, just because it was created on that legal pad on that desk, does not constitute a public record. Those are materials that are purely personal in nature. Drafts and notes, anything that you yourself are preparing just as to jog your memory down the line, or something that you're working on in terms of an official memo or document, those are not public records. They're not disclosable. But the minute you take that draft or note and you share it, I'm not going to say always, but you run the risk of making it a public record as soon as it is shared. So again, when we look at the definition of this category of documents, think about them being unique and personal to the individual creating that particular note or memo or whatever draft. And if it extends beyond just purely personal in terms of that interest, it's going to be a public record.
Yeah, and I would just jump in here. There's, let's just call it urban myth, right? There's a lot of urban myth when it comes to public records, open meetings, right? And I think it's important that we are able to point individuals.
Is it urban myth or urban legend? I've always heard urban legend.
It was myths, because they're myths. It's a myth, or
Anyways,
maybe
okay,
legend,
I don't know that that's
yeah.
important, but I was
A
just
key
curious.
distinction raised by Attorney Phillips here. Now I've lost my train of thought. So when you're dealing with drafts, we see this a lot where, and again, I think we've made this point in the past, we'll make it right here. I don't think in the public records context, when people raise some of these points, that there's an intent to undermine the public records law. And so, right, whether it's legend or myth, it's just you have these exceptions, and they've kind of grown over time. Right, as Andy said, it's a pretty narrow exemption in that the draft has to be kept to kind of, I call it kind of an inner circle. And so I think the gray that we see is where, okay, let's say you have a contract, you're drafting a contract, it's clearly in draft form, right? You're still making edits, you're working through the contract. I've always interpreted kind of the exemption to apply so that you have your kind of your team, your bubble. And, so if you're a department head and you have a key, you're working with corp counsel, and maybe your assistant is helping with this draft, right? You're still kind of in that draft bubble. I think to Andy's point, and again, I don't think it's intentional, but this mistake we see made is, okay, we have this draft contract and corp counsel's been working with the department head and going back and forth with edits. And at some point, somebody sends this draft to 10 other county employees, two different department heads, 3 different staff members, throw in a county board supervisor. I think the problem is you could maybe still make the argument, well, these are the key players in this negotiation. The bigger that circle gets, I think the more difficult it is to make the argument that this was made for the originator's personal use or in the name of that person. I think it's hard to say if you got a group of 15 people that this original draft is for your personal use. You're clearly getting edits from kind of people outside that original drafting bubble. And so just be careful to not over designate things as drafts, or if you are in a draft status, again, if you're a department head, or maybe, if you're in a county where a supervisor is going to get involved and you're working with corp counsel, make sure it's a tight circle, and that when it actually is ready to be distributed to a larger group, just be ready for the reality that you're probably not working with a draft at this point, or you are, but it's a draft that's going to be subject to a public records request.
Yeah, and I would say even if it's one person that you're distributing to, your example was corporation counsel and a county board member. They're working on a contract, great. I think as soon as there are drafts going back and forth between corporation counsel and board member, you run the risk. It's not automatic. You run the risk that it's no longer considered a draft. Now, you still have the privilege issue to deal with. All right. This public records law does not eliminate or obviate the attorney-client privilege. That's an exception to disclosure. That's one of the statutory exceptions that we referenced earlier. That, however, is not one of the exceptions identified in 19.32 sub 2. So again, in my mind, as soon as you take those materials and distribute them, you run the risk of disclosure under the public records law. Very important distinction. Here's why this exists. And I always talk to people about this, is that we have a public records law in Wisconsin. We do not have a public information law. The public has no right to get information from a county, but the public does have a right to get records from a county. Very important distinction. Let me just address this. Go ahead.
Yeah, we see a good question here from Eric relating to the custodian of records on social media. So let's just answer that quickly before we get too far from that conversation. So again, I think it's analogous to a text situation. So even, right, if it's something that's on a server, not necessarily controlled by the county, you're still creating potentially a record. At least I think our position has been, when you're dealing with social media platforms, obviously, you know, Facebook, LinkedIn, Twitter, those aren't platforms owned or operated by the county, but as a public official or a staff member, if you're using them to communicate, it's again that content that I think you are the custodian at that point. You have an obligation to review those platforms and to capture any responsive records, whether or not you know, that medium is owned or operated by the county, which obviously in that case it's not. But again, it's not the device, it's not the platform, it's the content of the record. And so, like I said, from a practical standpoint, it can get very cumbersome and tedious to try to go through those platforms. So from a practical standpoint, I don't think we necessarily encourage people to not use those platforms, but just be mindful. If you're going to have a long conversation with a constituent, maybe at some point flip from the social media platform to your county email, so that in the event there's a public records request, it's going to be a lot easier to capture them.
Oh, I always say that. I hate social media for that very reason. It's impossible to monitor and it's impossible to comply with the public records law. I shouldn't say impossible. It's very, very time consuming and difficult. All right, Nicholas Trimner, who is, I think both of us recognize, incredibly bright and talented. He agrees with me that it's legend, not myth.
Okay.
For the record, he also says, what are the consequences for a failure to follow a rule or policy by an elected official to use required emails? Great question. I think you have to have board rules in place, and then the consequences are the same consequences we have for acting outside of those board rules. Not a simple answer to that one necessarily, Nick, but you have to put it into your board rules.
So I was just, I literally had that question yesterday, right? I mean, obviously, at least and I know Andy agrees, you know, we hesitate to necessarily scare board members, but the reality is, and if you have, I guess, a member or a staff member, but in all likelihood, probably a supervisor that is really hesitating to use county email, and, you know, it may be worth noting that at the end of the day, they, under Chapter 19, as a local public official, have an obligation to comply with county board rules, to comply with state statute. And so at the end of the day, when there's a public records request, there's an ethical and statutory obligation on the part of that member to actually secure records that are responsive. And I just had this conversation yesterday where, you know, you play out that scenario. If there's a public records request and a supervisor has said, you know, I have nothing. Well, I mean, right, the end game potentially is that if there's litigation and you have an in-camera review by a court, and it turns out, well, in fact, that supervisor had a number of responsive records, right? The liability there's certainly some county liability, but there's personal liability under Chapter 19 for that county supervisor. And so again, I always hesitate to necessarily scare them, but I think you can frame it more in the sense that there's lots of obligations one takes on when they, you know, raise that right hand and are sworn in as a supervisor. One of them is to comply with the requirements under Chapter 19 for open meetings, public records, and ethics.
So when do draft minutes become official records? They lose draft form as soon as they're approved by a committee. And so in my estimation, if we have draft minutes that have not been approved, you have the ability to claim draft status on those, and they're not a public record. Do we have any comments on a record retention program like Archive Social? We do not get involved in the technology aspects of this. We went into the law to avoid math and technology, so we follow that. But I love the fact that there's technology out there to assist us with compliance. So we would really encourage counties to look into it and share information. If you know of a good program out there that helps, absolutely share it with others.
I have heard of that one. And again, if you don't have a program like this, the reality is a supervisor is going through all their various platforms to capture the records. So if you can use something like that, it's going to make everybody's job a lot easier.
All right, so let's move on here to try to get through some more substance. Requests don't have to be in writing. When a request comes in, the requester does not have to put it in writing. They can walk up to the window and ask for records, and they don't have to identify themselves. So they don't even have to tell you the purpose of that. Now, that being said, when we see these disputes arise as it relates to, for example, somebody requests all emails sent between county board members and county staff for the last 3 years, we know that's overly broad. We know that really, we can say that the request is overly broad, therefore we can avoid responding to the request. But for one reason or another, we may want to try to treat this particular situation with kid gloves. We know that the requester is in the community, has a strong voice in the community. We know that the requester has an issue with a particular resolution that was adopted at the previous meeting. And so we may reach out to the requester and have a discussion with the requester about narrowing the scope of that request and so on. So we say this, that if you follow the law to a T, you're going to be just fine. But being just fine under the law is different than being just fine in the eyes of the community. We want to be both. We want to be good under the law and good as it relates to public relations with the community. So we really encourage having discussions with requesters when it is appropriate. It's not always going to be appropriate, but when it is appropriate. They don't have to tell you the purpose of a records request, but there's nothing in the law prohibiting you from asking and saying, look, you don't have to tell me if you don't want to, but are you really looking for information about that resolution we adopted last month that I know you got a significant problem with? If so, let's narrow this request and I can get you the information that you need quicker without having a back and forth in writing about the breadth of this particular request. So just keep that in mind.
Another urban legend. And I don't know, I guess this one's a head scratcher for me. I hear all the time. Well, we can't communicate with the requester. I have no idea why that.
I have no idea where that would come from.
Yeah, because to Andy's point, and again, there's no requirement that a requester provide the reason for the request, but in my experience, most requesters are open to communication. They're open to maybe giving even, and we'll get to this in a second here, as far as specificity, but just have that conversation. Hey, what are you really looking for? We're absolutely, and particularly if you're coming from the standpoint, we're going to fulfill the request if we can. If there's responsive records, we're going to get them to you. We'll get them to you, in a timely fashion. But can you help us kind of provide more clarity? I think 99 out of 100 times a requester is going to be open to having that conversation.
They're going to thank you and they're going to engage, and that's exactly what you want. That's good public service.
Right.
So I agree. A couple of questions quick. There are special rules relating to inmates that we're not going to get into in detail in this presentation. It is covered in the Attorney General's compliance guide. That compliance guide, we have a link to it at the end of this presentation, but it's the Office of Open Government that the Attorney General maintains. Excellent resource for questions on open meetings and public records. So take a look at that compliance guide. As it relates to inmates, the special rules, they do have to identify themselves. The records to be produced have to be specific or relate to that particular inmate. So we have a question here about what if somebody asked for a question about another inmate in the county jail. If it's the inmate asking the question, you do have a statutory basis to deny that request. Again, work with your court counsel to make sure that you're covering yourself under that statute. So we talked about the discussion as it relates to the requester requesting overly broad information in statute. The request has to be reasonably specific as to subject matter and length of time involved. Statute doesn't define what reasonably specific is. And so that's where sometimes a conversation can help you. All right. We can't simply deny a request simply because we think it could be narrowed. If it is not overly broad, we have an obligation to produce the records that are requested. Remember, go back to the very beginning of this discussion. That is part of our essential function to respond to public records requests and provide information to the public vis-a-vis these records requests. And so you can't simply say, hey, we think that you can narrow this request, therefore we're denying. If it's a valid request, you have to fill that request, all right?
Yeah, I think there's a lot of important, and again, we're trying to get through this so we can get through all the slides. There's a ton of important information on those previous two slides, because I think there's this response, I think, from a lot of authorities that if a request will result in a significant amount of records, that in and of itself is a reason to deny. That is not how Wisconsin courts have approached that, right? It's the scope of the request. So in other words, if somebody is requesting every communication relating to numerous subjects over a 20-year period, that's where you're getting into the territory of just simply overly broad, unduly burdensome, and it's going to impact the operations of an office. If somebody provides a very specific request, I want every draft resolution relating to a very specific thing, or not draft, but every resolution relating to a very specific subject matter over a set period of time, and the result is a significant number of records, you're probably going to be in the territory of you just need to work through that request and get the records, because it's going to be difficult to say that that request is overly broad or not specific enough. And there's a number of cases on this point that simply because some request is going to produce a large volume of records does not serve as a basis for denial.
Well, and it gets to this point on this slide too, is that the response has to be provided as soon as practicable and without delay. That's not defined in statute. The Attorney General has said that that means within 10 business days, but there is no law on that. There is no bright line rule establishing a deadline for responding to the request. So look at this last bullet point on this slide. It says, to avoid misunderstandings, it may be prudent. All right, we put this in here, lawyers, and we like to hedge our bets with everything, but I will tell you right now that I will always say it is always prudent that if you have to do some digging for records and it's going to take you some time to do some digging, locate those records and get back to the requester, reach out to the requester and let them know you're working on it. Because if they don't hear that you're working on it, they're going to assume that you are neglecting them, ignoring them, or you have some nefarious purpose in not responding. So always, always, always get back to the requester, even if it's a simple one-line email saying, I'm working on it, I'll get back to you shortly. That's it, okay? Get back to the requester and let them know. Again, setting the law aside from a public service, customer service standpoint, it's always good to provide that level of service to a requester, regardless of who that requester may be, even if it's a serial requester and it's distasteful for us to do it, deliver good customer service. If you deliver good customer service, you're going to comply with the law.
Another one of those legends where a request must be fulfilled within 10 days pursuant to the DOJ compliance guide, right? So this is one where you typically see that on the requester side, where you need to, for your own purposes, kind of set the record straight. To Andy's point, immediately acknowledge receipt. That's all you're doing. You're acknowledging receipt of the request. That's what DOJ, even there, it's a suggestion, I think a strong suggestion, but that you acknowledge receipt within 10 days. But if you have a records request that's going to result in a lot of records, or it's going to take time to locate those records, to Andy's point, just communicate that to the requester immediately or as soon as you can. Acknowledge receipt of the request and then lay out exactly, hey, this is going to take some time to locate the records. Something we really haven't touched on too much is that you're going to have situations potentially where records need to be reviewed to protect, protected health information or other exempted information that may be embedded within a record that's otherwise subject to a request. And in other words, it may require some redacting, all of which are going to take time, but to communicate that to the requester so that they know what's going on. And in that situation, even if it takes a month or 2 or 3 months, if you've communicated, hey, this is a big request, we're going to work as hard as we can to satisfy it, but there's a number of things that need to take place, you're going to put yourself in a good position so that the requester either is satisfied, or for worst case scenario, they bring some sort of challenge, you're going to be able to point to these communications and say, hey, we immediately acknowledge receipt. We laid out exactly what we had to do to comply with this request, and it's going to take time. Courts typically view that pretty favorably.
No, judges are going to give counties some latitude. Judges understand how extensive these requests can be and understand the job that we have as counties in filling those requests. And so if we lay out that process and communicate with the requester, a judge is not going to punish us. In most cases, I'm not going to say in every case, but in most cases, judges won't. A couple of quick points on denying a request. If a request is in writing, we have to deny in writing. That denial has to be specific and provide the reasons for the denial of access. We can't simply take that stamp on the side of our desk that says denied and stamp it on the request and send it back. That's not sufficient. We have to provide either the statutory basis, the common law basis. In other words, there's a court decision that confirms our denial, or the balancing test. And when we talk about the balancing test, we have to show what we went through in that balancing test. We weighed the harms to the public in disclosure against the harms to the public in maintaining confidentiality. And I'm sorry, confidentiality wins, and here's why. You lay all that out in narrative form. I've seen these responsive denials where we've gone through the balancing test, or even when we've relied upon some common law exemption, 2-3 pages in terms of the explanation. Why? Because that's going to be exhibit A in a lawsuit that's filed. Again, We want to show the judge that we took our job seriously. We want to show the judge that we went through the statutory process of reaching a conclusion that denial was appropriate. And the only way we show that judge how we went through all of this is to lay it all out in written form. So please be careful on that.
And not to get too far into the weeds, but Andy and I have had to litigate these cases. The final important point is when you're laying out those reasons, and again, hopefully you don't ever get into the position where you're litigating it, but the entire analysis has to be laid out. If you get sued and then you're litigating a matter, you can't after the fact present an additional justification for withholding a record. In essence, you have to show every reason under the balancing test. If there's any statutory exemptions, they have to be laid out in that denial. Because if you don't, you're not going to be able to raise that argument after the litigation has been initiated.
We've tried to.
It doesn't work.
It doesn't work well.
It doesn't work well.
I'm still going to try it in the future if that happens again. But Jake's absolutely right.
So
every single conceivable reason under the sun as to why you're denying access within that responsive letter.
just one other point on that. So that's a point really in the weeds. The other point I want to raise is more the 30,000 foot point of when you're working through these, make sure you're clear when you're communicating if you're actually denying. And I know it sounds like a really basic point, but for example, I think there's some hesitancy where if you're asking for further clarification or you're asking for, I guess that would be the scenario, right? You're asking for additional clarification. We want to make clear at that point in time, we're not denying the request, right? Because to Andy's point, like when you're actually at that final stage, when you're maybe providing some records, but denying other requests, right? That we want to get all the reasons in that communication. And then at that point, there's going to be the right to appeal that decision. And so when you're having these communications, make sure that the requester understands, and I guess maybe that's ultimately my point, make sure the requester understands that we're not at the point where there's any denial, right? We're just having a conversation, seeking more clarification, right? Because when we deny, it's going to be very clear as to why we are, and then we're at that point where if they still disagree, we're then in the situation where there could be an appeal.
Well, and that's why even if we withhold disclosure on a part of a record, redact it, then we have to provide the reason for the redaction. So we have to put that in the response. And then the final statement in every response, if we are denying access to a record, is that we have to advise, this is the public records Miranda, we have to advise the requester they have the right to seek review of our determination through the local district attorney or the attorney general's office. And I'm going to move ahead here. I'm going to try to plug through. We've got 22 minutes left and a lot of slides. And so we're going to try to move a little quicker here. All right. Redaction. We don't get to charge for redaction. We get to charge for location. We get to charge for copies. We don't get to charge for redaction. It's a frustration. It's something we've attempted to address with the legislature over the years, but there is no appetite to reopen the public records law and allow us to charge for redaction. It can be expensive because if we're talking about, for example, the attorney-client privilege, we're going to have our corporation counsel or our outside counsel go through that record and redact. That's going to cost us money. Too bad. We don't get to charge the requester for that redaction. There's a limited duty to notify a record subject as it relates to a records request that comes in. This stems from the Weidner case. It's 19.356 of the statutes. Two categories. We've got employees and we've got officials treated differently under 19.356. Again, we're not going to get into detail, but if you get a record request that comes in specific to an investigatory or disciplinary matter involving an employee or official, your antenna should go up that 19.356 exists, and you need to speak with corporation counsel about the particular process you need to go through to notify the record subject about the existence of this request and their ability to try to seek to get a judicial order to seek that record not be disclosed.
I don't know if it's maybe just a sign of the times with polarization or what, but I think we've seen an uptick in requests for personnel files relating to staff, requests for communications, even supervisor to supervisor. Well, which again, if you're dealing with staff, it's going to be a Weidner notice, for example, if they're requesting some investigatory files. If it's a public official, they're going to have a right to augment those records. So I think just from a commentary standpoint, we're seeing an uptick in those. And it's important just to be mindful. So that this is more just kind of one of those red flag issues. You need to red flag a request like that to remind yourself that the notice needs to be provided. Because we've seen situations where there's a failure to provide the notice, and that's a whole different bucket of problems.
Yeah, let me deal with a couple of questions here that we've got here. The point in the Attorney General's compliance guide about an authority maintaining a policy as it relates to records requests. Yes, any authority, if as authority is defined in the statutes, has to have a policy and has to have a copy of that policy at its offices. Question, if a complaint's called in, are we obligated to share the caller's name? Depends. I mean, it depends. If that caller's name was not written down, you don't have to share anything. It's not a record, but depending upon the circumstances, you might have to share. Medical records, are they public? There's a specific statute, both in federal and state law, that protects confidentiality of healthcare records. So you have to evaluate if the record falls within those particular statutes. Question about ex-spouses requesting work schedules for use in a child custody dispute. Is that a public record? Potentially. I mean, typically speaking, schedules of employees are not typically confidential, but I mean, depending upon the circumstances, again, the balancing test may say you don't disclose, but there's no flat out prohibition on disclosure.
Right. That's a perfect example of kind of where just a really sticky application of the balancing test would come into play.
Now we're going to get into some of the topics that we don't typically cover as it relates to this presentation. And when I say that, I mean that we're digging into the weeds on the whole electronic information issue. It's an issue that didn't exist when the public records law was created, but it is a big issue now because we are creating records at such a rapid pace when you look at it from now compared to, for example, 1975. All right. To Jake's earlier point, it's the content that determines whether a document's a record, not the format or medium in which it is stored. It's the content that determines that, okay? So when we look at this whole concept or question of personal devices, we've touched upon this earlier, and we've talked about the need for policy and procedure of pushing everything through county system. Well, there hasn't been a court case that's reached the Court of Appeals or the Supreme Court here in Wisconsin, but we've got cases in other states that cause us to have a lot of heartburn and concern about the what if we have a request that comes in for information contained on a personal device, and for whatever reason, that particular official does not want to turn over that personal device to fulfill the records request. Under the California Public Records Law, a judge ordered a supervisor to turn over a personal device so that the court can review the information contained on that personal device. I don't know about anybody else here, but I do not want a court taking a look at my phone and all of the contents of my phone. Not that there's necessarily anything harmful on there, but why would I want to give up all of the information that is incredibly private and personal to me, give that over to a court for the court's consumption? Wouldn't want to do it. Same thing happened in Nevada. Again, I think the last bullet point here is really important for us to remember. The court concluded whenever a communication pertains to the provision of public services, the communication is a record subject to public disclosure under the Nevada Public Records Act. That gets to the point earlier that we talked about, that it is the content and of the record of the information that determines whether it is a record, not the medium, format, or location. So we have this broad statement in Wisconsin law, and when it comes to application of that statement under Nevada law, we have a court saying, yes, that's entirely true. Then we have this case from Washington in 2015. Physical text messages that weren't produced, they're subject to disclosure in the Public Records Act. And so we get into a situation where our personal devices can have all sorts of text messages. What can we do on our personal device with text messages? We can delete them. What is the record that is created as a result? Can we call up? In my case, we've got Verizon. So if you call Verizon and say, send me a transcript of all text messages from the last 37 days for Andy Phillips' cell phone? No, they don't maintain that. They don't have that. Is there technology that may be able to extract that from this? Yeah, that technology exists. Can that technology be overridden? Yes, it can be overridden. And is there a problem under the public records law if you destroy a public record? Yes, you open yourself up to a punitive damages claim. We don't want that. And so all of these statements about what if, and all of these cases from primarily the West Coast, these are designed to scare everybody into saying we definitely need a policy. And we definitely want to make sure that county business is conducted on county devices. That way, we are not opening a court. We're not providing the opening to a court to look at personal devices, personal computers, personal laptops, and so on. Push everything through county systems.
I mean, I would just make the more comment here, despite these cases being outside of Wisconsin, therefore, really just probably persuasive value. I mean, looking at the body of case law interpreting, chapter 19, I just see no scenario. I know it's a pretty strong statement, but I don't see any scenario in which if this actually became a litigated issue, i.e. you have a supervisor that's refusing to search a personal cell phone that may or may not contain county related text. I just don't see any scenario in which a court wouldn't find that under the cases that have been interpreting chapter 19 since the 70s, that there wouldn't be an expectation that those will be considered records. So we may just be at the point where we may never see a case because I just don't see that argument really.
No, I totally agree. I think it's a loser argument to say, well, it's on my personal phone, so therefore you don't get access to it. That's a loser argument, and there's no way it's going to happen. All right. So we provided in this presentation a step-by-step guide for handling records requests when they come in, getting back to the point of having a procedure in place for handling these records requests within your county. Whoever the custodians are, make sure they understand this step-by-step analysis, and then also understand that there are requests that come in where corporation counsel needs to be alerted and needs to be involved, if for no other reason to simply confirm that the analysis that somebody went through is the appropriate analysis. Now, I'm going to spend the last 15 minutes today talking about some of the developments that we've got in the public records law. We're going to talk about the Friends of Frame Park decision. That was a Supreme Court decision from, was it last year, Jake, or the year before? It was last year. The Giro case, which is a Court of Appeals decision from, I think that was either late last year or early this year. We've got the Leaders decision, Krug, that's a 2016-17 case, and the Weidner case that came out last year as well. So Friends of Frame Park deals with the whole question of entitlement to attorney's fees. And before Jake talks about the aspects of this case, I want to very specifically address this whole issue that we see out there, which is the weaponization of the public records law. And when I say weaponization, what I mean is somebody sends a request in, and as soon as day 11 hits and you haven't responded to that request, they're going to run to court and they're going to sue you to get access to those records. They're going to file a mandamus claim. And you're going to say, wait a second, I was working on this request. And so you filed your lawsuit early. Here are all your records. Dismiss the lawsuit. Their response is going to be, yeah, I'll dismiss the lawsuit, but you also have to pay me $1,000 to cover the filing fee and the attorney's fees, because there's a fee shifting provision in the public records law. If a requester prevails in a court case, that requester gets paid not only for the filing fees, but also the attorney fees associated with bringing the claim. So it's that weaponization of the public records law that frustrates me. Frame Park took a look at the question of when is somebody entitled to attorney's fees if they are successful in creating a response to the records request vis-a-vis court action. Jake, why don't you talk about it a little bit?
Yeah, so this case came out of the city of Waukesha, and I think it's really important to understand the background, because all of you that work in public records are going to kind of recognize a lot of the points, frankly, that we've just been talking about and how they kind of came into focus. So Friends of Frame Park, it was a development of a baseball stadium in the city of Waukesha. So there's this nonprofit, Friends of Frame Park. They opened a public recorded numerous records. Ultimately, what the focus was essentially on the draft contract between the city and this Big Top Baseball Incorporated. And ultimately, the city took the position that because the city's negotiating bargaining position could be compromised by the public disclosure, that it was a draft and therefore not subject to a public records request. Taxpayers filed a lawsuit in Waukesha County. And this is really a key point, 2 days later. So 2 days after the filing of the complaint, their common council meeting took place. The city releases the draft contract to the group. Okay, remember, we have pending litigation. Circuit Court ruled for the city, concluding that Waukesha properly withheld certain public records temporarily in response to the record request. For the Friends group appeals the decision. The appeals court reverses that Judge Bourne's decision, holding that Waukesha's decision to withhold the draft contract while negotiating, quote, was unwarranted and led to an unreasonable delay in the record's release, and ordered that the taxpayer group was entitled to some portion of its attorney's fees. So that's the Court of Appeals decision. Fast forward, Supreme Court reverses Court of Appeals, and a very contentious, complicated, convoluted, however you want to describe it, it's a Judge Hagedorn lead, or Justice Hagedorn lead decision, but very convoluted, 4-3 decision, finding that the people seeking information by an open records request resulting in a lawsuit are only entitled to attorney's fees if there is, quote, some judicially sanctioned change in the parties' legal relationship. And I note the dissent here, and this will make sense in a second here, a very strongly worded dissent focused on the chilling kind of effect of that decision. And I note the dissent because what has transpired since is 2023 Assembly Bill 117, which passed the Senate April of this year. That bill would supersede the Supreme Court's decision in Friends of Frame Park and essentially return to pre-Friends of Frame Park. And so this is right from the bill summary from LRB. Under the bill, a requester has prevailed in whole or in substantial part, so it's still using that language, if the requester has obtained relief through any of the following means: a judicial order, so that obviously still would control. This is the really important point. We go essentially pre-Friends of Frame Park. The authority is going to obtain relief if they've voluntarily or unilaterally released a record if the court determines that the filing of the mandamus action was a substantial factor contributing to that voluntary or unilateral release. So there still is a court determination, but it would essentially address that situation where you have litigation filed. Again, Friends of Frame Park, 2 days later, they release the record. Who's prevailed in that situation? I think it's probably fair to say that under this SB 117, the court would make a determination that the filing of the mandamus action was the factor, the substantial factor. And why is that important? Because then plaintiffs are going to be entitled to their attorney's fees, potentially.
All right, let's talk about the Giro case here too. In Giro, this really was, I think, the second coming, if you will, of the Erpenbach case involving certain information that is unrelated to the particular authority, but the authority has this information. In the Erpenbach case, it happened to be the content of emails that constituents had sent to Senator Erpenbach, and the court said, no, you got to disclose the content of those emails. Those individuals sending emails to Senator Erpenbach had no expectation of privacy in their communications. They sent the emails to a public official subject to public records law. Here we have the Giro case where a school district gathers information about parents and kids. The information about the kids, that's subject to the People Records Law, and so it's not going to be disclosable. But what about email addresses that relate to the parents? You want to talk about Giro?
Yeah, so I mean, well, and there's a lot of politics going on with this case. This is actually in Andy in my backyard, because as Andy said, I wouldn't really say it's necessarily new law. It's really a reiteration of some previous decisions focusing on kind of the content, or excuse me, the contact information, right? Because ultimately the issue here is an email list. And I'm looking at the decision right now. The email list is the actual record. That was a determination from the Court of Appeals. The district I talk about kind of the chilling effect that will occur. And the court basically said, well, that's largely speculation. And then the court even noted that in the past, the district had a practice of releasing the records. And so I specifically kind of note kind of the political nature of this case, because I think it's pretty clear now, the Court of Appeals in numerous decisions has been pretty firm that if you have contact information that's not otherwise exempted, right? So you just have an email list that the district is using or the county is using to distribute information, the email addresses are going to be subject to a request. And so that's important because I don't think it was frivolous to say that, there could have a chilling effect. It's certainly possible that, well, if it's known now that the county or a district or town has to release those email addresses, individuals may hesitate to give that out, but the courts just have not viewed that argument favorably.
I mean, the weird thing is okay, let's say that you have a county newsletter, and so you have a button on your website that says, sign up here for our county newsletter. And when you click the button, a form comes up and it says, give me your first name, give me your last name, give me your email address. Okay, great. That form is probably going to auto-populate some sort of mail merge feature within Excel or some other program that creates your newsletter mailing list. Somebody can request and say, send me your email newsletter mailing list. And that is a record and that is disclosable. Bureau confirms that, even though I, as a member of the public, would not reasonably expect that email list to be made public subject to a public records request. Doesn't matter what I thought. I provided the information, authority, the county compiled that information, created a record. That record is going to be disclosable. So that's the important part of Bureau.
And it's important, I think important point, kind of a subtle point that Andy is making is that's maybe a reason to put the public on notice, right? To have that disclaimer language that information provided via this medium may or may not be subject to a public records request. So that almost from a PR standpoint, in the event you have to release that information, you can point to the fact that, look, we've made you aware that this is potentially subject to a public records request.
The Leaders case, the Leaders v. Krug, this is a really interesting case. And I say this because we have this debate all the time, is that somebody will request, use my prior example, somebody requests all of the emails that happened between the board and a particular department within the county over the course of the last year, because there's some big issue going on with that particular department. So I want to see all the emails. Well, we may say, let's take all of the emails, let's put them into PDF format, and let's send that particular requester a flash drive containing all of the PDFs associated with those emails. The requester may say that's sufficient. I just want to see the content of the emails. But what happens if the requester says, no, I want those emails in resident format. If you use Outlook as your email management system, I want them in a PST file or some other file that is going to retain the metadata associated with those emails. And so then you dig into the question of what really is the record? Does the record really contain the metadata? And the metadata, by the way, will show all of the keystrokes, edits, deletes, modifications associated with that particular message as you're putting it together. And so, yeah, the court said the metadata, it's not contained on the paper printouts or the PDF. And so if the requester wants that metadata, that requester can ask for the metadata. Now, the thing that's interesting from my standpoint, at least, that isn't litigated in Leaders and I think needs to be litigated, is what about the exception for drafts or notes? If I'm in draft form, is the metadata a draft of the ultimate message that becomes the email? I think a good faith argument can be made that that metadata represents the draft of the email. Now, there may be certain attributes of the metadata that are not so-called draft. We really have to evaluate that from a technology standpoint as to what the metadata shows. But I think that this whole issue, the litigation, the disputes that arise as a result of wanting electronic information in resident format, I think that's far from over in terms of the dispute. Again, it'd be awesome if the legislature could help us define what is going to be considered part of the record, but the legislature, again, has no appetite to open up the public records law, at least not for these types of issues. And then let's talk about the Weidner case. The Weidner case I bring to your attention simply because this is a situation Jake and I get involved in, where typically we will go into closed session with a particular board or committee of a county client to have a discussion about pending or anticipated litigation. In that closed session, we may distribute materials to the committee or board members. And then at the end of that closed session, we'll gather all that material back and take it back with us so as to avoid inadvertent disclosure of the written materials and the advice provided to that client. The Weidner case involved a similar circumstance with the Racine Common Council. Racine City Attorney goes into closed session with Racine Common Council, provides a PowerPoint presentation, not written form, but a PowerPoint presentation up on the screen, going through the various elements of a particular case in which the city is involved. After the meeting, one of the members of the Common Council says, send me a copy of that PowerPoint. City Attorney's Office says, no way, I'm not doing it. That's a privileged communication. Court of Appeals in a summary disposition order. So this is not precedential. This isn't a published case. Access to it because it's not privileged. She was there. Now, it begs the question, depending upon the circumstances, as to who the consult with him or her a lot about these questions, about to whom the privilege attaches, so you don't avoid inadvertent disclosure and essentially obviating the attorney-client privilege. But understand that we have, just because you're in closed session under 1G and you're having a conversation with a lawyer does not automatically mean that everything discussed in that meeting is subject to privilege. So we talked about this previously. There is a terrific resource online, the Public Records Compliance Guide. Consult it. Want to recognize the local government center at UW Extension. They have done a lot of work in the area of public records, and we've utilized some of their slides in putting our PowerPoint together. Also want to recognize Paul Ferguson in the Office of Open Government at the Attorney General's office. He maintains what's called the PROM line, the Public Records Open Meetings Hotline. If you ever have a question about public records, or for that matter, open meetings, call Paul. He is a terrific resource. We've collaborated with him an awful lot over the years on interpretation and application of the public records law. So with that, we're at the end of the presentation. We will keep this open for a couple of minutes to see if we have any questions or comments that float in. But otherwise, we are done 1 minute late. Sorry, we kept you 1 minute over, but we thank you for your interest in this topic. And in the future, if you have questions or concerns about application of the public records law, reach out to the Counties Association, reach out to me, reach out to Jake. We'd be happy to work through this with you. And I will tell you this, on some of these difficult questions, there are no easy answers. It involves quite a bit of thought. So don't think just because you may be confused or concerned about a particular topic, you're not alone. A lot of us are confused and concerned. So thank you for your attention to this very important issue. Sarah, do you want to have any closing thoughts or comments here as we sign off?
Yes, I do. Thank you very much, Jake and Andy. Again, this was wonderful as always, and lots of good information for us to ponder and think about as we think about the public records law. I always learn something every time I listen to you guys talk about this. So as we just wait for a couple more questions to filter in, I just want to remind everybody that we do hold in the boardroom the fourth Wednesday of every month. Our June meeting, our June date would be June 28th of 2023. And the topic in June will be dams, where Jake will be joining us to discuss lots of fun issues related to dams. So I'm just looking to see, Jake, I understand.
Sarah, that's not the official title. Are you just afraid to say it?
I don't have actually, you know what, Andy? I didn't look up the official title. So I don't have it on me. I could, if you give me, I could look it up. I could look it up.
I'll let you off the hook.
You can let me off the hook, and I don't want to say anything inappropriate while being on the on the webinar. So if I say the title, I don't know.
Webinar.
Let me say this too, is that if anybody has any topics they would like to see explored in greater detail, I know that Jake and I and the Counties Association, we do a lot of workshops throughout the state on issues that are common to counties. But if you have, say, you know what, I'd like to see a more detailed discussion, a deeper dive on a particular topic, send it to Sarah, send it to us, and we'll get it on the agenda for a future in the boardroom.
And I do have a new topic for you, Andy, from my meeting last night, so I will let you know. All right, you want to answer these couple of questions that have just come in real quickly?
Somebody's being asked to willingly revoke, or I would say waive, the attorney-client privilege to provide communication between corporation counsel and myself. I've refused, as I believe privilege should be preserved. Right or wrong answer? Typically, I would say right answer, but confer with your lawyer to make sure that you're making the right answer. But I think that's always going to be the initial reaction pending a conversation with your corporation counsel. Second, is there an easier way to find the webinars on your website? Sarah, that's a technical question for you, not for us.
Yes, I am working. I am trying to find an easier way within the current confines and construct of our website to make these easier for you to find. They are listed under, you have to go under the events page of our website, and then you have to go under past event materials. And then there's a section in there called In the Boardroom where you can find all of these. In the meantime, I am trying to work with our folks to see if there's an easier way in which to find our In the Boardroom materials, because I get asked this question quite a bit. So I'm trying to think if there's anything else. I'm not seeing anything else in the chat or in the Q&A. So I think it's time for us to sign off, as we've already kept folks 5 minutes past our ending time. But again, thank you so much, Jake and Andy, for presenting today. And again, we hope to see you on June 28th, where we are going to talk about dams. So thank you, everyone, and have a great rest of your day.
Thank you, everybody.
Thank you.